Opening the meeting for the Special Committee on the Family Division of the Circuit Court of the State of New Hampshire. And it is good to welcome back Christina Dyer. Thank you. Your substitute, Wednesday Adams, filled in admirably for you. In fact, bore a significant similarity. But good to have you back anyway. I'm going to ask for reports from the working groups. We had 4 working groups, and off you went to discuss various things. Before we start, the speaker would like to have an interim report from this group. So when each work group makes your report, we will probably ask a few things to be included in it if it's good, and ask you to get it back to us pretty quickly, so then next week at our meeting we can vote on this being part of our report. I would like to start with the Committee on Forms, and the chair recognizes the wife of the Street and Sidewalk Commissioner from the city of Nashua, newly elected.
Thank you, Mr. Chairman. Yeah, he's Board of Public Works, but we're very excited for him. Very excited for Nashua, actually. So thank you, though. So I'm sorry, I'm not. So you just want me to give you the update on where we're at with our forms committee and stuff, correct? Our report? Okay.
Just give us an update.
You threw me with that introduction. It was very exciting. So with the subcommittee on forms, we actually had a meeting. Well, first, actually, Judge Ashley came and spoke before the entire committee and really gave us a very informative update on where they are with forms. I think that there's been a consensus that they have been paying attention, but even before that, they were already aware that there were some hiccups in the forms. They went from having each court area having different forms to all getting the same forms. So now that they all have the same, they're looking at how can they simplify that. In our subcommittee meeting, we met with a clerk, and what was great about that was actually it was unintentional, but Representative Ball was there, and you were there, Chairman Pearson. And Representative Ball actually demonstrated how it's actually hard to find the forms on the website. So they were able to see that firsthand. But they do have steps going forward, starting with the fact that right now they're getting quotes on people that can come in and kind of work through the forms and stuff. They're also,
what's the technical term? Request for,
it's an
anybody remember what that is? Anybody?
RFP. Yes, thank you.
Request for proposal?
Yeah, request for proposals. So they need to do that. They're hoping to figure out which company in the next 6 months, and then they'll start working. They are going to have some feedback. They have been paying attention. They have been watching the feedback that we have. One of the things that we talked about is making it more accessible. We did demonstrate to them legal aid, a New Hampshire legal aid. They have a page that's very easily traversed. And so they're also looking at that. They were going to talk to them about who they use to see if there's something that they can do that would also follow that, because it is so easy to look at. So what we decided at that subcommittee meeting was really just to keep communication open. We'll keep those lines open, but I don't think there's anything necessary really from us other than if they ask for feedback. And I'm interested to check in with them. I have it on my calendar to check in a few months to see how those RFPs went and to see where they are in that process. But they are hoping, they have funds to do it. So they're hoping within the next year or so to start having some implementations.
You invited 3 people to the subcommittee meeting, did you?
I did. And
well, what kind of people?
Well, from the
nice people, I know that. But
they were from the courts, and I knew that you were going to ask me first, and I should have had it ready, but instead we were talking, so I apologize. So we had we had the Heather Culp, who is the Circuit Court Senior Administrator, and then we also had Elaine Lowe, who is the Conway Clerk. Ossipee and Conway clerk. And Judge Ashley was here actually the time before, so we did not have her come back. So both of those came back, and than the three of us. So it was a really small meeting. It was warmer that day than the time before. But yeah, that was really our work. Unfortunately, and this is how it should be, the judicial branch had already taken the steps to go ahead and start fixing this issue. They knew it was an issue. They could see as they've been watching our committee meetings the level of the issue, so they were already taking those necessary steps. But I do think from Judge Ashley, it was already kind of in their plan. It just spurred them to do it a little bit quicker. So I think we're in a really good place with that.
At the end of the meeting, you'll recall I asked the clerks, would they mind terribly if we kind of insinuated ourselves into the process? And you remember their response. They not only did they not mind it, they said they'd welcome it.
Yes, they're very open to communication and feedback, and that's also why right now I think they said they thought it would take about actually they're thinking that the overall work might be done in 6 months. So at that 6 to 9 months. So in 2 months is when I have marked on my calendar to check in with them and see where we are and see if they need any feedback. But they also have contacts for all of us, and we have their contacts. So that way, if something comes up for us, we can tell them, but also if they have any questions. So they do know that we've gotten a lot of comments and stuff on the forms, and just so they know that they can contact us on that too. So open communication.
When we started this special committee, or even before we first met, I met with the Chief Justice of the Supreme Court and also Administrative Judge David King, and suggested that I want to gang up with them to fix problems rather than ganging up against them. We've seen too much of ganging up against people. And they said that's what they would like as well. Somebody said, did I trust them? I said, yes, until they give me reason not to. And they haven't. And they are listening to what we do, whether live or, by recording, and anticipating. And it was, to me, a tremendous thing to go in and hear. They're already doing it even before we told them to. Yeah. Would you write up everything you just recited and send it to us in the next couple of days, please, so we can vote on this?
Absolutely. I have it written up, so I will send it
Were
to
you
everyone.
reading that only looking like you were?
No, I was trying to find it,
Well,
so I'm
you-
not that prepared. I need like coffee through the IV today.
Well, I
but,
thought you did a
yeah.
good job. Thank
Okay.
you. So
Thank you.
send us all that, and we can read it over the weekend and vote on it next week.
Sounds good. Thank you.
Thank you. So that's the special subcommittee group on forms. I'd like to call on Vice Chair Smith, if you would, for judicial training, education, supervision, and accountability, and RSA 490F.6 should be reviewed.
Good morning, Mr. Chair, and I will not be as thorough or complete as my Nashua colleague, because I've been struggling with some of this, and I know those on the subcommittee have been struggling. And it begins, Mr. Chair, because family court cases are among the most complex that a circuit court judge faces. Even if a judge is familiar with the law, and almost no judges appointed to the circuit court are, the application of the law might very well have no bearing on solving the painful, complex, idiosyncratic questions that brought the party to the court in the first place. We have listened carefully, as I think everyone has, to the testimony, the very painful testimony that has been presented to this committee. But in addition, we have tried to identify sources that perhaps bring some more neutral perspective to the issues, because we do have to acknowledge that overwhelmingly, probably no one wants to be in the family court. they just as soon not have those problems that have to be resolved. But in most cases, they're resolved with people not necessarily all feeling happy, but willing to attempt to abide by the judge's decisions. And those people who have come before us, as important as their experience is, and I don't think any of us would want to minimize that, do not necessarily represent the mainstream of those people who go through the court. But it is important to take seriously what they say. We looked at materials that came from a lot of sources, but the one that I know I found particularly helpful is the Family Justice Initiative, Principles for Family Justice Reform, that were published in 2019, not that long ago, by the National Center for State Courts. And their general thinking is something that I want to share with everybody, and I hope we will share in our report. Divorce, separation, and parental responsibility cases often present complicated emotional and non-legal issues, requiring a family court judge to have familiarity with theories and research in disciplines such as social work, psychology, and dispute resolution. The principles in this report and in others include understanding child development, family dynamics, child abuse, substance abuse. Relevant intervention strategies and standards have to be applied in order to end up with outcomes that might be helpful at all. And then you have issues like bankruptcy law, immigration, which I hadn't focused on, but is incredibly important, and criminal law. And so, to begin with, as chair, I question the basic premise that the judicial arena is the appropriate place to resolve these differences. Who is looking at each case to identify child development issues, implicit bias, and other non-judicial but extremely relevant factors? But charged with addressing the obvious problems within the existing structure, there are certain threshold issues. The need to ensure that those appointed to sit on family law court matters on the circuit court have relevant education and experience. And in situations where they have experience, there has to be an evaluation of how they performed in those circumstances. Once appointed, we believe strongly that the newly seated judge must undergo training focusing on the intricacies of the family court. In order for the judge to carry out his or her judicial duties, the circuit court staffing must mirror that of the Supreme and Superior Courts, in that there must be a sufficient number of clerks to support the justices. Now you might wonder why, charged with looking at education and accountability, we would presume to mention the presence or absence of clerks. We think it's central to how the judges are able to carry out their business. They have to do everything that they have to do sitting at the bench. They have to write the reports. They have to process the reports. They have to make sure that the extraneous information and materials are involved. All of this makes it impossible to devote the appropriate amount of time to actually carrying out the direct judicial duties. We know that there are time lags that we shouldn't have in the system, and believe that having additional staff support could make that important. We know that in many cases, the decision is written in almost in, if not necessarily in shorthand, but in an abbreviated manner, where the judge says, "Yeah, I decided X," but does not have the time to say, "And the reason I decided X is because this was the testimony. This is what I found from supporting or opposing documents. This is why I ended up where I did." It's all well and good to make a decision, but unless people know why that decision is made, it might be very hard for them to accept it. And so all of that could be helped if there were, in fact, enough staff support. Um, uh, we then we did look at Supreme Court Rule 5. We looked at the memorandum from Judges Dave King and Susan Ashley that was dated October 2nd. And we, on the one hand, were very pleased that they recognized that we needed to have an organized educational effort. But truthfully, and this is this is not anything that I don't know if anybody else agrees, but personally, I was surprised that understanding the absence of staff, the caseloads, the pressure, all of the other things that need to be done, that the proposal was to create I don't have the page in front of me, unfortunately, because I couldn't carry it all today given the weather. But to create something called roughly the New Hampshire Judicial Training College. With all due respect, we're a long way from needing a training college. What we need is someone on the staff who has the responsibility for making sure that every judge has access to the training that is essential for them to carry out their jobs, and that they have the time to take advantage of that training, not 6 months or 12 months after they have started in the family courts, but at the beginning. And all of that, I understand, costs money, and the money component is the responsibility of the legislature, but it is important for the judicial branch to understand, to be committed to explaining to the legislature, which is a better way of putting it, I think, that they understand the need for training, the need for supervision, the need for accountability, and that they in fact have a plan to do that. The last thing the legislature should be doing is doing the judicial branch's business. And there's much more to be said, much more to be looked at. I think I've probably talked long enough to give you a feeling of where we're going. And I hope you will accept the fact that our report that we will submit to you next week will be a preliminary report, and hoping that we will have opportunity to do a lot more in terms of identifying best practices across the country and relating those to the realities of how the New Hampshire court system operates, and the hope that we can get all of us closer to the best possible system. Thank you, Mr. Chair.
And with that, I would ask anyone else who served on the Judicial Training, Education, Supervision, Accountability Subcommittee, if you have something to add to what the subgroup's chair has just eloquently given us, this is the time to say it. Anyone else from that subcommittee? Hearing nothing. Would you type that all up and send it out over the weekend to us, please?
I will do my best.
And as I have emailed before, what I would like is just also list who is in attendance at the meetings.
Okay, as I say, I will do the best that I
I'm
can.
sure you will. And we'll look at all of this now over the weekend and come back, as many of us as can, next Tuesday to make some decisions about a preliminary interim report. Next subcommittee was the GAL/parenting coordinator role. And who do I call upon for that? Did you chair that, didn't you?
I did, but I
You-
wasn't there. But I'm happy to speak on it. I should watch it.
But you tuned in.
Yes.
Of course you did.
Yes.
So you were the named chair. So if you could give us the lead off, and then we could call on the others who were there as well.
Sure. So the GAL/parenting coordinator subcommittee met. I unfortunately wasn't able to make it, so Representative Long was kind enough to fill in as chair for me that day. Thank you very much, Rep. Long.
He rode that
And-
to victory in the Manchester election, by the way.
Wonderful. And attorney Aaron Cregan from the court attended as well and was there to answer many questions, as well as took home quite a few questions that the group had. She was able to respond to many of the questions. I think there was one outstanding question that I had in my notes. And I think at this point, the group needs to come together based on the information that we've received and see what further may need to be done. So my recommendation would be that we have another meeting to see if we have enough data based on the information that we got back from Attorney Cregan to be able to make any recommendations, or if we feel like we need to do any more research. But I do think that we do need to have another meeting as a subcommittee to go over the information we've received and see a path forward. And in terms of the parenting coordinator piece, I did, prior to the filing deadline, put in kind of a placeholder bill so that we'd have something in there. It was as thorough as I could be for the parenting coordinator piece, but the GAL piece is something that's really already in there. And so that's much more involved. So there's no placeholder for that. And that would be the place where I think we really need to discuss and see what may need to be done there, if anything, and what our recommendations will be, because the other piece of it is a financial piece, in that much of what we heard was that indigent parties who can't afford a GAL are often turned away, and it's not a budget year, so I'm not sure that that's necessarily going to be possible now, but maybe that's more of a recommendation that we make for the next budget. So I think we really need to come back together and discuss all of that.
I have reserved, because of calendar deadline issues, next Tuesday, November 14th at 9:30 for the special committee as a work session. And just keep that in the back of your mind. It might be one or two of the subcommittees could be meeting, and then all of us at, say, 11 o'clock or something. If, this is just an ill-formed thought trying to coalesce. Just hold that idea. Or maybe you would want to schedule a meeting of this subcommittee for a little bit later on. That would come past our deadline for making our interim report, possibly. Or we could schedule another meeting of the whole subcommittee later on. I mean, this is just all options we have, but we would like to get the interim report in this year. Vice Chair, please.
Mr. Chair, could you flesh out your idea? Frequently, interim reports are tend to be brief and tend to identify not so much what has happened, but where the body wants to go. My understanding is that we have another full year
We do.
before we have a detailed final report. And all of that, one would hope, would be done and distributed so that information that might affect the next budget process would already be, people would be aware of it. But, so I just want to know how much you really want for this interim report.
I think we want something more than a sketchy outline and something less than a complete final report.
Okay, thank you. Somewhere on the continuum, Mr. Chair.
Squaring the circle.
Okay.
Yes. And in terms of discussion, not only is the judiciary paying attention and walking with us and sometimes actually leading us on, I get to meet with the chairman of finance at least once a week. We both represent Kingston and East Kingston. And he is really starting to warm up to the suggestion of not only in the next budget do we need more judges, we need clerks in the circuit court, we need a trainer, we need supervisors. I'm feeding it to him in ways that he understands how financially this is a very responsible thing to do.
That is wonderful news, Mr. Chairman. I do want to point out to you that it is theoretically possible that the distinguished representative with whom I have served on finance for many years might in fact not be the chair of the Finance Committee.
It could be.
We also know that no matter what happens, the incumbent governor will not be the governor. And by this coming spring, the budget process itself actually begins to start with each of the departments having to begin to get information in so that it is also a very good news that you give us that the judicial branch is paying attention, and one would hope would make sure that some of these directions are reflected in the plan that they're probably almost ready to begin on for the next budget.
Well, I'm keeping my eye on developments, and right now I intend to dance with the gal I brought to the dance. And should something happen along the way, I am flexible.
I'm delighted to hear that, and I can't very well dance right now, but I would do it if I could.
And perhaps you and I could meet. Thank you. The fourth of the four working groups was on the subject of rules of evidence. And, you know, as you're making your wish list for next month, I heartily recommend, and I believe Representative Gregg would agree with me, that you put on your wish list the rules of evidence, almost 300 pages. It doesn't come stained, dog-eared, and watermarked. That's because I've read it through 4 times, slowly, thoroughly, read the footnotes, looked up the cross-references. It's a great book. I'm just waiting for the movie to come out. So here's my report as chairman of the Rules of Evidence Subcommittee. Additional members were Representatives Ball, Gregg, Long, and McMahon. These 5 are all from the Children and Family Law Committee, because that committee would later have to decide on House Bill 475, establishing a right to submit evidence and testimony in family court proceedings, and House Bill 499, requiring the rules of evidence to apply in family court cases and relative to the admission of certain evidence in family court proceedings, to use their titles. So the reason I picked the 5 of us from Children and Family Law to be this subcommittee is we would be dealing with it anyway, and here we are. Now, I was given this copy of Rules of Evidence. It is subtitled, with reporter's notes, as updated by the New Hampshire Bar Association Rules of Evidence Committee, published in 2023. Testimony before our special committee. This special committee, as well as before Children and Family Law, often centered around, as the people giving testimony said, how a judge refused to accept proffered pieces of evidence from one of the litigants, or refused an objection to the acceptance of evidence from the other litigant. In other words, the whole question of rules of evidence was a source of much testimony. And the two bills submitted to us would put strong restrictions, prohibitions, mandates on the judges. They demanded, many of them demanded judges accept all evidence proffered in any form, unlimited, as one bill said, by the presiding judge, magistrate, or marital master, or by the New Hampshire Rules of Evidence, or the rules of the Circuit Court Family Division. In other words, if somebody wants a piece of evidence in, that piece of evidence must come in. Assertions were made that this or that judge was biased in one direction or another based on a perceived imbalance in rulings about evidence. Always favored the woman, or always favored the man, or would take anything, or would take nothing. We remember those hearings. Several things emerged as I read through the book. Rules of Evidence allows a judge to refuse a piece of evidence to be admitted if it does not enhance the case. That is, it does not add or detract from the likely verdict. Now, if the judge did not have the power to do that, the trial could go on indefinitely. People could keep bringing in more, quote, evidence, and the judge would have his or her hands bound, must accept it. And yet, we keep hearing from testimony the cases drag on too long. Well, folks, you can't have it both ways. Page 31, each single piece of evidence must have a plus value. Well, according to whom? One of the bills said, according to the person who gives it. Well, of course. But who says that person is unbiased? Of course. Well, should the judge not hold the discretionary power ultimately to decide whether a piece of evidence enhances the case or is simply dragging it on? Secondly, Rules of Evidence allows the judge to refuse a piece of evidence to be admitted if its probative value was substantially outweighed by the danger of unfair prejudice. For those of you who are not familiar with the legal term, that means the value, that's probative, the value of a piece of evidence to prove something is much smaller than the potential inappropriate harm either to the case or to another person. And this is a case where we've heard testimony too. The other side dragged in a piece of evidence which really didn't help the case, but served to ridicule the opponent. And I think we've heard objections to that. So if the judge cannot rule on the probative value being less than likely harm, then we're going to see a lot more of weaponization of evidence. Page 39. Rules of Evidence allows for the judge to refuse evidence of other crimes when prior bad acts are in some significant way connected to material events constituting the crime charged and not so remote in time as to eliminate the nexus. What that basically means is you cannot bring in evidence of a past crime if it's only tangentially related to the case at hand. For example, in a sexual matter, one could not drag in all kinds of things that somebody did in college if it has no or minimal relevance and only serves to embarrass. That's page 65. Now, I could go on for a long time. I was actually having fun doing this, but I think you get the point. In each of the three examples, in my opinion, it must be up to the judge to decide whether something is relevant, inappropriately harmful, whether it's connected, and so on. These are judgment calls. And in one case, the decision could go one way, in another case, it could go that way, because they're not always exactly identical. So no fixed law or rule can accurately fit every case. This is why on several occasions, Rules of Evidence, the book, states clearly the rules of evidence are not mandatory in circuit court. They give guidance, but the judge has to use discretion. And research indicates this is how civil court works in most states. And in a few where a wooden, literal following of the rules of evidence is mandated, it is believed that a substantial advantage is given to the litigant who is a lawyer or who has studied the law extensively over against the litigant pro se, who is neither a lawyer nor well-studied, but simply representing him or herself. That seems to be the answer that I'm hearing as I spot checked. So the conclusion that our subgroup, which really was a subcommittee of children and family law, came up with, is we ultimately must not tie the hands of the judges. However, there does seem to be a few judges where bias, intentional or otherwise, might possibly be true. So if we can't tie their hands, and yet there seems to be a pattern that we should not want, how do we square this circle? During the executive session in Children and Family Law, I introduced an amendment 2023-2324H, which would replace one of the bills in its entirety. And the amendment reads this way: if the court admits evidence or testimony over the objection of one of the parties, or the court chooses not to admit evidence or testimony offered by one of the parties, the court shall note in the record the reason for its decision. If the belief is that the judges always rule in a wise, fair, and impartial manner, it should admit no embarrassment for the judge to say, this is why I ruled, because the judge believes him or herself to be wise, fair, and impartial. And that's why the judge made the ruling to admit or exclude a piece of evidence. So just tell us why. I'm sure you knew why. That's why you did it. So no penalty there to probably just about everybody. But my suggestion to the judiciary is that they significantly increase the review of cases, particularly of those judges where a significant number of concerns have been raised about that judge's evidentiary rulings. Such review may correctly conclude that this judge was, after all, wise, fair, and impartial in most, if not all, of his or her rulings. Or the conclusion might go in another direction, warranting some continuing education, warranting monitoring of a particular judge. Something that, by the way, happens now, but we would suggest should happen more. And if this problem persists, perhaps some disciplinary action could be taken. An escalating thing where someone somehow is not responding to the continuing education to bring that judge back into some kind of balance. Now, I believe this amendment, this suggestion for monitoring, would address the question of alleged impropriety while not hamstringing the judges where they need to have discretion. Trust but verify. For the record, House Bill 475, as amended by the amendment I just read, passed the Children and Family Law Committee 16-0, and the somewhat parallel bill, now that we've dealt with the issue, was ITL 16-0. My recommendation to all of us is that we give the above a try for a year. If it works, we've squared the circle. And if it doesn't, we can always come back and try again. So that's my report as chairing the subcommittee on rules of evidence. And anyone from that subcommittee wishes to speak. Not accepting anything. No, whatever, but I'm not accepting anything. So anybody from the subcommittee wish to comment? Representative McMahon, Long, Gregg, or Ball? No? I'm sorry?
Yeah, you articulated it well. That's exactly what I recalled.
I think all of us working together came to a pretty good similar place. So that is pretty much my report, and I will email it to everybody. Representative, Madam Vice Chair.
Thank you very much. That was a very thorough and impressive report, and I thank you very much for it. One of thought that struck me is how closely so much of what you discussed intersected with the concept of training, supervision, et cetera, and also the need for clerks in order to be able to do what you specifically direct the judges to do, which is to record in more detail than they would have the time or ability to do under these circumstances why they have made certain decisions, so that coming in your silo, so to speak, and the training, supervision, accountability silo, we end up at the same place. And that, I think, indicates that we might be on the right track.
Madam Vice Chair, if I may, I would like to take what you just said and add it to my report with a footnote, of course, just to talk about how two of the subcommittees working on somewhat different things have come to very similar conclusions at the meeting place. So I think I'd like to do that.
Good.
Yes, Representative Macbeth.
Oh, so actually, I had a question. You hadn't called for that yet. I think you were asking other members of the committee to.
Well, okay, other members on the committee. Representative Macbeth.
So the bill, I was following you, and then at the end, you got kind of fast talking.
I do that.
So,
I could be a lawyer.
so clarification, so there's a bill that the Family Law Committee is going to put forward, two bills, and you're going to ask or require family court judges to, within their orders, write regarding why they did or did not accept evidence. I mean, generally, that's something that's done from the bench. I think and a transcript or an audio recording that you can get for $25 would provide that information. But are you asking, because, we've seen the evidence that we've gotten, 25 pages, 100 pages. So I'm just wanted to clarify, are you asking for a written explanation about evidentiary rulings within a family court proceeding?
House Bill 475 as amended and passed by CFL Committee 16-0 onto consent would do exactly that. That if a judge says, no, I'm not allowing that piece of evidence in, there is a note as to why, and it may be a very brief phrase. Or if yes, over the objection of the other litigant, I am accepting that piece of evidence, here's why.
So I would ask, I mean, that for me, and I'm, my experience is only limited to mine, but in a family court hearing, even a 30-minute hearing, you could have 20 rulings on individual package of 100 pieces, and the recording of that, I think it goes back to
Only if there's
what
an
Representative Smith said.
Yeah.
Well, no, if you're going to submit evidence, doesn't have to be an objection. You're still going to have to, whoever's trying to get it in.
No. It's only if there's an objection.
Your bills, okay.
Yeah. Only if there's an objection. And therefore, the judge has to make a ruling. If there's no objection, there it is. But if there is an objection, there has to be a ruling. We just simply believe the judge knows what he or she is doing and then not just pulling rabbits out of hats. And since the judge knows what he or she is doing, give me a phrase as to why. It does not advance the case, period. Or its probative value is outweighed by harm to others or the case. Simply write it down.
That I think that definitely, I mean, my experience is only my own, but my experience is that New Hampshire judges in family court they don't just say no, they'll say, if there's an objection, lack of foundation.
Okay.
Or whatever. But
Then it's written down. It will be written
no.
down. The transcript will be.
well, it's not written in the order. It's in the transcript. I guess
Okay.
that's what I'm trying to. Okay. That's a lot of, yeah.
The allegations were made that judges arbitrarily do this, and numbers of people say, and we were never told why. I'm not going to argue whether that is truth or fiction. Let's say, for the purpose of argument, it's truth. The judge made a ruling and never said why. Now the judge will say why. And if the judges almost always say why, there'll be very few cases where this amendment actually forces the judge to do something else.
And just to clarify then, the litigant would go back and look at the transcript, and then if the judge didn't say why, that would be brought forward?
We will, I suspect, leave that to the judiciary how they wish to do it. My hope would be an administrative clerk hearing or getting wind that Judge Snodgrass, I hope there's no Judge Snodgrass in New Hampshire. If there is, I apologize. Or any of us have relatives named Snodgrass. Judge XYZ, how's that? The rumor on the street is XYZ always favors this side. Well, okay, let's go spot check. Or somebody on appeal. And remember, to appeal, it must be an error in law or procedure. It isn't just, I lost, I hate that, I'm appealing. You know that. I learned that. Those would be the cases. What I want to do is to be able to say to those who have come in here and said a certain thing that we hear it. And to the degree, we're able to do this, we want to answer it. I personally would be very surprised. There would be a lot of cases where the judge is prejudiced, but let's find that out. I'd like to be proven, no, there isn't. But if there is, we need to know that. That's all this is doing. I don't want to use the phrase silence the critics. I want to listen to what the critics are saying, and to the degree they're correct, I want there to be some changes. And to the degree they're wrong, stop making these criticisms. Representative Long.
Thank you, Mr. Chairman. And with that also, the CFL committee did consider the added burden on the judges, that how it would be more complicated or give them more work. And we came to the conclusion that it was just a note as to why or why not. And it was only for evidence that he didn't accept, or one litigant was able to put in evidence and the other litigant was not able to. So give me a footnote as to why the other litigant wasn't able to. So it's not on every order that, every order with respect to evidence that the judge makes. It's not that. The high number of pro se, the judge may have said, I'm not considering that issue, so I'm not accepting your evidence. As a pro se, I forget that as soon as I walk out the door, and I'm thinking, hey, how come he didn't take my evidence? I didn't hear it. This way here, it's written, everybody knows, and it just makes it clearer. It makes it easier for the pro se to know that they're being considered, and they have clear reason why evidence was taken or not taken in their cases. I mean, it's addressing the pro se more or less, and that's what the legislators hear most, is from pro se people that feel that they're being biased against, and we're looking to give them a clearer understanding.
In a way, it also levels the field, because if somebody says objection the next thing the judge will say is on what grounds. And I don't like it isn't grounds for, making an objection. So one of the litigants says, objection, Your Honor, the objector should give a reason. And when the judge makes a ruling, the judge should have a reason. Representative Macbeth.
So I understand and I appreciate it. I've approached this a little bit differently when allegations of wrongdoing or inadequate explanations have been provided, testimony, and I've talked with the citizens that have come. I've asked them to show me. I thought that what the proof of what they are alleging, and that's the point where they can't provide it. So as far as I'm, there's Children and Family Law's done a lot. The annotation of that type of a decision, I can't imagine how I mean, I don't see that on, U.S. Supreme Court cases. So I
That's another book I haven't read. We're just dealing with.
but no,
family court.
I think you'll be able to work it out. And I think, it is important to respond to the citizens and what their concerns are and to try to figure out to do that in a way that balances, good judicial process and time that we have.
See, if a family court case, at least one of the parties had a lawyer, the lawyer would speak with the client ahead of time about evidence and whether it should be offered, if there's foundation for offering that evidence. And if there isn't any, I'm sure the lawyer would say, well, he's going to rule against you, so don't bother. But in a pro se, well,
That's not my experience.
well, okay, and that's why I haven't gone to law school yet. I understand this will come up in the first year with contracts, but never mind. 80% has one or both parties pro se in family court, we've been repeatedly told. So they may not know this, that you better have a reason for asking a piece of evidence to be admitted and why it might be ruled against you, but many people don't. So this will level the field, I think. Anything else, anyone else on rules of evidence? I will add your wonderful comments about how it connects and get this out to you over the weekend. Now, one question. We've had 4 subcommittees, and the question before us will be, does the subcommittee need to meet more, or are we done? Forms. Okay, done. Judicial training.
I'm not confident about an answer right now on that. I do know the reality is that all of us are scrambling to go down 2 roads right now. One, finish all the bills that we have from last session and prepare for the bills that are about to fall on us for the next session, so that I am hesitant about adding anything that is not required. There's not a time limit requirement right now, but I would hope that perhaps after the first of the year, we could get together again and say, okay, now we've had a preliminary report. Where do we want to go from here? I just don't think it's fair to try to do something right now, I guess, is my response.
So the suggestion is, let's put this on the back burner and revisit getting the band back together again next year?
That would be my suggestion, but it's just my.
That's good. Others in that work group, what do you think? I hear nodding. Okay, good. Rules of evidence, I really think we're done. GAL/parenting coordinator, Representative Katab is speaking of a placeholder bill on parenting coordinator. And I think I heard you say that more work needs to be done on GAL. So you'd like your subgroup to continue?
Yes, please.
Okay.
I don't think that it needs to be something that's urgently done because I guess I don't want to speak for the committee, but I asking if you feel this way, that this is something more that we can put into the final report rather than necessarily proposing a bill right now, causing us to urgently meet. Do you feel that we could put it in the report? Okay.
So let's have it in the preliminary report, and maybe the subcommittee can be backburnered for next year at some point. And you
Yeah, I
give-
can put together a preliminary report based on the
Okay.
questions that were asked of Attorney Cregan and the data that we've gotten so far, as well as,
Okay.
you know, I think the parenting coordinator piece of the parenting/GAL had been very briefly brought up. I had put in again that placeholder bill for it, and I think because of that, it was more focusing on the GAL piece. But I think we were kind of okay with what had been put forward for parenting coordinator. Am I okay? So the parenting coordinator piece is kind of in, and it's the GAL piece that'll be a report. You know, going more details into the final report.
Very good. Now, the next question that I had sent you several times is, we received a lot of testimony and the clerks put them into categories from which 4 subcommittees were formed. I have down here on a printout a couple of other, perhaps, categories to start a new subcommittee. And I have down here child support and domestic violence. And since Representative, your fingerprints are on both of these, would you speak to them, please?
So the child support piece, Rep Ball and I worked over the summer to try and talk to many of the stakeholders about some of this, including the family law attorneys, and hearing feedback from many of them. We kind of put something together, and then Vice Chair Smith was kind enough to meet with me and somebody on the other side of the wall to go over some of what we had come up with, just to get consensus, because what came out of it was we looked back and there had been child support bill after child support bill, year after year after year, that's constantly ITL'd. And so there were reasons why. In the minutes I went through and I read all of the minutes that were available, and tried to see what are the reasons that it's being ITL'd, and make sure that this bill wasn't going to be in conflict with the reasons where it had previously been ITL. Because I think much of the testimony that we heard is parents need help on this, especially when there's the shared parenting time and parties are making approximately equal amounts of money. If parent A makes $10 more than parent B, they're then ordered to pay the full child support amount, which may be $1,000 a month. And then the other parent is in essence then making more money than this parent. And it's difficult for them to then afford to do the things that they need to be able to do with their kids. So that piece, there is a bill in for that. And it is my hope that since there was so much input on that the bill will finally pass this year.
Is that a 2023 bill that was retained?
No,
That's a 2024 bill.
correct.
So is it your belief that that's where all the heavy lifting should be done, is around that particular bill, and we will not need a special subcommittee of us, or not?
I don't believe that we will. I think, I'd like to hear if anybody else has any.
Anybody else? Representative Long?
Thank you, Mr. Chairman. That is, as long as I've served on children and family law, those two are the issues. Those are the two that clash, and it's made me my decision sometimes, a lot of times uneasy, but I go for the benefit of the doubt. I don't believe they need to be separate subcommittees. But like Representative Katab said, it's always been the decision as to why or not good child support criterias have been killed because of domestic violence, getting caught up in the child support.
Yeah, so I didn't actually speak to the domestic violence piece. I apologize. This was just the child support piece. But the domestic violence piece, I think that is something that is like kind of put as a criteria for like the shared parenting time piece, why there may need to be a deviation for that. So I think they're kind of related in some ways, but then not necessarily, because once the parenting time is decided, then the child support is decided afterwards. So the DV piece, I did not work on a bunch. Somebody from the Judiciary Committee had put in a bill requiring or an LSR requiring electronic filing. That's the only work that I know that's moving forward as of now regarding domestic violence.
So I would be under the assumption that the child support bill in 2024 would, like its predecessor, come to the Children and Family Law Committee, and probably the best thing to do is when that does land with us, we can just set aside a good chunk of time and invite, but we do not need a separate subcommittee of this special committee. All the heavy work will be done in CFL. Okay. Yeah, that seems to be the consensus. All right, no sub. Now DV, what about that? If to your knowledge, anybody's knowledge, that's the only DV LSR that was sent in, perhaps we do need a working group on the subject? Is that a fair assumption? What do you think? I mean, the right number to do it is 1, not 2, and not 0. What do people think? Representative Gregg is reaching for the button. There she is.
Thank you. I'm not sure that this, I mean, part of this and our, looking at the family courts, obviously we've had some cases that have had domestic violence and whatnot, and we've looked at, I just don't know that that's the charge under here. Once again, I think that that's something that will come up I mean, the fact that we don't have any bills really filed with DV is disturbing, but I think the things that we need to look at are not going to be something that we would be doing on the special commission. I think once again, that would be something that CFL would be carrying the load on that.
Are you about to? The chair recognizes the vice chair for an
Well,
about
thank
to.
you. Yes, but Representative Gregg said exactly what I was thinking. There is no reason for the special committee to take over work of and responsibility of standing policy committees in the legislature. And we have in the past had experiences not very pleasant where we recognized the crossover among 3 committees, really, which is the criminal justice, children and family law, and judiciary, on issues relating to domestic violence. But I think I don't see any reason to put that responsibility before the special committee. I believe, I can't speak for my colleague from Wyndham, but I believe that the experience for those of us who are on judiciary and not on children and family, to be exposed to certain of the painful realities that people are facing. We've had an exposure here in this committee that we haven't necessarily had in judiciary, for example. But I don't think in the end that it's the responsibility of of the special committee to do that work, and so that the work that our colleague has done to actually file some LSRs, I think she has done as an individual rather than as a representative of this committee, working on knowledge that she gained from this committee, which is how we all gain knowledge. We certainly don't want, I don't believe we want a new bill that will come to committees in January to be assigned to the special committee.
Representative Ball.
Vice Chair, thank you for recognizing me. I just had a clarification question. When you said those other three committees came together before, would our recommendation be to bring those three committees again to look at DV as in the overall as to whether it should be in family court or whether it should be in criminal court, or where does it fall? Or just to have an open discussion, because we had so many people come and testify. So I'm just wondering if that might be our recommendation, is that there be a different committee solely to look at that, that piece.
Representative Bo, that is a fascinating question. And I think a very important question. And I am either happy or unhappy to say I don't have an answer to that question. It is possible that we might want to suggest that another special time-limited committee be formed, perhaps with representatives from criminal justice, children and family, and judiciary, to decide, is there a better way for the legislative branch to, and therefore then the results of that would of course affect the other branches, to address the incredibly serious problem of domestic violence. And the speaker might moan and groan at the thought of, oh dear, but we ought to think about that. That might end up being a recommendation that doesn't fall within any of the standing committees, but recognize that all of those committees have an oar in that boat. That's a very interesting idea.
What do others think here that in our interim report of next week, we have a line item that at least suggests perhaps just that perhaps a special committee on DV would be named out of CFL, Judiciary, and Crim Justice, and simply put it, Representative Long.
Thank you, Mr. Chairman. Just I'm feeling in Manchester, the lack of supervised visitations. There's been arrests in the library. There's exchanges happening in the library. Police are called in. They're not set up for that. And my understanding that from the Library Association that it's worse in town libraries because it's smaller. Manchester, we have security. We have a detector you go through. However, in the smaller towns, it's more onerous to get, a police officer there when you only got two in a town. So I think that's another, that that's going to be coming to a boil, I think. I think the new committee would suffice that, answering those questions. We absolutely need.
Anyone else who hasn't yet spoken on the issue of perhaps having this as a line item recommendation in our interim report that we'll vote on next week? Anyone who hasn't spoken to that yet?
Thank
The
you.
chair recognizes Representative Gray.
Thank you, Mr. Chairman. So I did speak kind of just that I didn't think it fell under this committee, but given, I mean, honestly, it's a global pandemic of domestic violence, but I do think that, you know, even looking at the little kind of tip of the iceberg that this particular commission has looked at, I think that it would be very important to have a committee like this. So I'm very versed on what laws we have and what we don't have in this state, and this is definitely something that would take an entire committee, not just a little piece of this one. It needs its own focus group on that.
Here's what I'll do. I'll write this up as a separate standalone thing besides what I'm writing for my subcommittee. And on Tuesday, when we look at the documents that we're all working on over the weekend to vote on them, we can again address that and have the weekend to think it through. Yes, Representative Macbeth.
Thank you, Mr.
Welcome.
Chairman. So I would just comment, you know, we had the Governor's Commission on Domestic Violence that
Yeah,
has,
yeah.
I mean, I would look at I will volunteer to look at what their recommendations are as far as moving forward into the legislature. But I think that really should be our springboard. That work has already been done by a lot of stakeholders, and it was a considerable amount of time with, everybody involved. So I think that might be the best place to look as far as if this committee is going to make a recommendation, I mean, to join and be informed. So, thank you.
Yes, frequently we forget in policy committees that the steak has already been cut and seasoned, and we don't have to start from square one. We can start from square four. We forget that too often. So thank you for the reminder. Representative, the Vice Chair.
Well, thank you. I think I appreciate Representative Macbeth's comments, and of course, she's absolutely right in acknowledging the fact that there are all kinds of groups out there addressing this issue, some with more success than others, some with more solid research than others. Some with different perspectives. And what has been missing, I think, is a consistent legislative approach. And just as in this committee, we listened to, of course, to the courts and to the GAL group, and we listened to when we had a former senator and judge and representative and chair Ned Gordon here with all of the hats he wears. I mean, we benefited a lot from knowing what other groups have done, and some of which we agree with in the end, some of which we didn't agree with in the end. But the basic point is a solid point. And the other important reality is, for reasons that we might surmise, but we do not know, domestic violence and related to it, child abuse, appears to be reaching pandemic status level. And I don't think anyone at this table can feel comfortable unless we try to do something. We might not be able to, but at least we should try.
Representative Katab.
So I absolutely agree with putting this together. And it was actually, I have the report right here from the governor's task force. It was actually a recommendation. The recommendation was a stakeholder group with expertise in the area of domestic violence should review existing New Hampshire statutes regarding domestic violence and determine whether any of the areas of review set forth above should be advanced through the legislative process. So they did make quite a few recommendations in here, and they did actually recommend a group getting together and going through that. So I would absolutely support that.
Somebody suggested this be these are my words, limited time, that it is not something that goes out a long period because a lot of the work has been done. And what you just read makes that even more clear. But a group of legislators reviewing all of this, answering what is said here, coming together to say, okay, let's put together an LSR that we can all live with out of all of this work that's being done would probably be a limited time, but I'll leave that to other people.
If I could, Mr. Chair, it's not necessarily an LSR. We're not going to, between now and, let's say, June, submit an LSR because we can't.
Right. Well,
And
no.
we shouldn't. And, but that is not to say that we shouldn't do this having nothing to do with the family court in terms of the process right now, and have it ready so that those of us who will have the privilege of returning to the House might very well be in a position to file LSRs, and those of us who aren't might be in a position to help advise those about who are here about how to continue. But so it's, the purpose isn't for an LSR. The purpose is to say what should be done by someone.
So it would give recommendations, and then an ad hoc group of prime sponsor, co-sponsors would wonderfully say, thank you very much. I'll just put my name on what you said,
Could be,
or tweak it because we have to, you know.
could
Yeah.
be.
Okay, good. Thank you. All right. I will, I'll have a little one pager that we can vote on. Representative Long. Yeah.
Thank you. Just a quick, that report date, the date on that report?
March 1st, 2022.
Thank you.
And the title is the Report of the Governor's Commission on DV. I have it somewhere.
So actually, so this one was a task force on domestic violence cases in the New Hampshire Judicial Branch. And
I have it.
there's a
Okay.
couple different reports that I have here. Yeah. So that was what came out of that one.
So my one pager could just simply say, and such a group drawn from these three policy committees will review various reports from commissions and judicial branch, and, you know, make it broad and collect new information, of course. So there are no new subcommittees so far. There's a one-pager on a recommendation for a committee to be formed. We've got medical training going to continue on the back burner. We've got GAL parenting to continue, especially with reference to GAL. That's on the back burner. Do we see any new subcommittees that need to be formed out of this group?
I don't.
That looks like a resounding no, but Representative Katap?
So I don't think we need any more work groups, but I do think that we did include some other topics, which is on the last page of what you have, just regarding things that should be in the final report.
Okay.
And I think we should definitely make sure that those items are addressed in the report. I don't know if they need to be addressed in the interim, but I do think some of them are important pieces. I know particularly one of the pieces, the principle of one judge, one family, and the concept of how that can be honored with the difficulties that the judiciary is currently facing. And I know that previously Vice Chair Smith had agreed to put that together to take the lead on that one. I think there's a few other topics here. I know obviously the forms ended up getting its own, and I think the visitation piece might actually be able to be covered a little bit in the DV piece, because the visitation piece was more along the lines of what he was saying, where there's difficulties with exchanges and whatnot now, especially where there's only the one supervised visitation center. So I guess those pieces.
So those are two things in the interim report. I can note that over the next year, heading towards the final report, we may be addressing issues such as one judge, one family. How about visitation apart from domestic violence issues? Would that be sufficient to look at?
So my hope, thank you for the question. My hope is that perhaps some of that can be addressed through the GAL/parenting coordinator, because I do think it's very difficult a lot of times for the court to decipher who may be an appropriate person for somebody that perhaps does need supervised visitation. We have a big substance abuse epidemic in our state, and I think it could be difficult for the judge to know when you've got, one parent that doesn't have a drug issue and the other parent does, and the parent that's fit and doesn't have the drug issue is saying no, no, no to everybody that the other parent is coming up with as a possible person. It's difficult for the judge to kind of weigh and say, well, are all these people really having problems, or is there just being unnecessary pushback here? So I think a lot of times they don't know from the bench. How could you make that decision? You need somebody else, boots on the ground, to actually meet with that person. Not as much of a level as DCYF does, but I mean, when somebody's going into foster care or whatnot, you send somebody out, see, is the house clean? Is it appropriate? And they even go and they do like mini checks kind of on the grandparents where the children may go. So I think, again, not to a huge extended level like that, but just going to see, is the home clean? Does this person seem reasonable, responsible, without issue, to kind of give the judge that feedback? I think that would help to very much so with the problem, because I think we don't have the centers, and I'm not sure that the state would be able to come up with the centers. I think it's more of a what else can we do, since we don't really have that as an option anymore.
I'd like to flag that as an item that may be addressed in the final report, tucked under the ongoing GAL parenting continuation of that subgroup. I want to flag it. I just feel that needs to be mentioned somewhere in the interim report, even though it's tucked under one of the subcommittees. Anything else? Yes,
I wanted to
Representative
agree with you for red
Macbeth,
flagging it.
yes, you're welcome. Go ahead.
Thank you. And also it's addictions and also child abuse. DV is part of it, but it's the child abuse or child neglect. So I think that our subcommittee would be good. I did miss the October 17th meeting, but I think that's a good place for us to look at that. Thank
Okay,
you.
Thank you. Anybody else? No, go on. No other subcommittees. Nobody wants a subcommittee over the December school vacation.
Got it.
Sounding no, sir, we do not. Okay, I think we've got enough for the 4 subcommittee chairs to make a report, and please get it to everybody by the end of the weekend so we can digest it on Monday. And Tuesday, I know at least one person will not be able to be here, and thank you for letting me know. But everybody else, if we can come here at 9:30 and go over as a final review of everything for the purpose of any tweaking, and then a final vote, and off it goes to at least the Speaker's office and all of us, and anybody else. Maybe we should charge for it. I don't know. That could raise some money for our party. How does that sound for next Tuesday? What's that?
Object to the part.
You object to the party.
I can't make it Tuesday morning. I apologize. I'll get everything in advance, though.
Okie doke. All we need is everybody else to be here.
Excuse me, I'm also having a conflict on Tuesday. Is there any possibility it could be moved to another date on a Thursday?
The one I was just going to ask, left the room.
Well, we can, Mr. Chair,
Yes, ma'am.
if you begin to see that there might be trouble with a quorum,
Mm-hmm.
you can always, cancel a meeting, even though it will be in
Your calendar.
the calendar, and it might still be able to be knocked from the
Yeah, well,
calendar for
I'll
today. I don't know.
grab-
But in any event, you can always cancel and reschedule.
Okay,
I
let me ask the question, who will be here on
I
Tuesday
can't be.
morning? Briefly, McMahon, Pearson, the spouse of the
No,
sidewalk
no,
super.
she's here on her
I
own.
know that. Representative Craig, Representative Long, Representative Ball.
I can be here on Tuesday.
You
but
can?
I can, but I would prefer Thursday, if it's possible.
Okay, I only have, you cannot, you will not.
I'm unclear on my times, but I know I could not be here. I could be here early and then late. I mean,
Okay,
that's,
9:30 is, it's called
No.
for. How about, let's take a look at, I first want to make sure I can be here. Simply for quorum purposes, 16th.
Yes.
Yeah, but, okay, thank you. Yeah, I know she does the scheduling. That wasn't what I wanted her for. But I'll take care of that.
Thanks, Betty.
Yeah, thanks, Betty. Who can be here on the 16th, Thursday at 9:30? Who can be here? No, 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 no. Yes, 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 yes. That's not a quorum. Uh,
Mr. Chair,
Yeah.
you know, it's not as desirable, but but you could do this without a meeting, in that you are submitting an interim report on behalf of the committee. You could ask and have asked each of us responsible for a section of this report to have it to everybody by the start of the weekend. People could get back to you by Tuesday or whatever day you set, and they will have either agreed to all the subsections or will have made some suggested changes. That would still give you whatever time you need to just assemble the pieces together, and we're not hearing testimony, we're not voting on a bill, we're not doing anything. You're calling the clerk.
Yeah, hi, Representative Pearson in the middle of a meeting, needing a review on something from the clerk, please. Now, we're trying to make a policy decision about whether an interim report
Procedure.
can be approved by email if we actually have to convene to vote, because we're having trouble getting a quorum on dates we're looking at. I don't think the statement coming out of the Speaker's office constituting this special committee mandated a report. But we're going to have an interim report. And the question is, do we all have to be present in the same room to vote that report? Or once it's ready, ask people by email for their approval? That's the question.
Let me have him get back to you.
Okay. Roughly, I don't mean to push, but we're about done our business and going our separate ways. How long might it be before he could answer that?
Hold on, if I can get him.
Okay, thank you.
calendar's already out. I mean, no, they,
Does anybody have the statement that constituted the establishment of that initial letter from the Speaker's office?
I don't have my folder with me. Wait, it-
I have, courtesy of Representative Long, the initial memorandum that establishes this committee. It does not say anything that I can see about a final report, where it goes, or anything like that. The Speaker has said to me he would like to have an interim report describing our work before we adjourn until the new year. My question is, do we have to approve that report in person with a quorum? Or may that interim report simply be approved by the members voting via email? The committee is the special committee on the family division of the Circuit Court of the state of New Hampshire that barely fits on one business card. Okay, you're trying him on his cell, are you? Okay. Do you have Karen Carwell? Actually, I can tell the clerk's office directly cancel the Tuesday meeting. Are you still on the phone?
Yes.
We would like to cancel our Tuesday meeting. We had sent in a request to have put into the next calendar a meeting of the special committee for Tuesday, November 14th at 9:30, and the committee would like to cancel that. I, as the chair, would like to cancel that meeting. So unless the calendar is already finished.
The calendar was sent out yesterday.
yesterday.
It came out yesterday?
Yeah,
Yeah, because the Veterans Day, we did it a day early. But that would also need to be done through the committee services.
Okay, that will have to go through House Committee Services. I can do that.
Yeah, I can't do that.
I'm sorry?
I can't.
Yeah, fine. That's it's fine. Do you have Karen Carwell? Yeah.
Like somebody just this morning already added an addendum. There's already a calendar.
but that
for
was
you
a,
that day.
that's an appendix for a hearing to be
Cancellations
held.
don't go in the addendum anyway.
It would go in the addendum anyway.
No, it wouldn't. But
No,
the
it goes
cancellations
on.
don't go in the addendum.
The question is, how can we vote? Because all the dates we're trying to do, Tuesday will not have a quorum. So we can meet on Tuesday, November 14th, but since the purpose was to vote, we will lack a quorum. We could not get a quorum for Thursday, November 16th either. So the question is, since a report is not mandated in the memorandum that sets us up, is it necessary to meet in person to approve our interim report, or may we do it by email? And I'd like to speak to the clerk directly if I can. I know, I've been there.
Hi, Mark.
Hi, Paul. The memorandum that sets up the special committee on family court does not mandate a report, but we would like to give an interim report to the speaker. However, we can't find a date to meet to do it. So once the report is finalized, I would like to poll the committee by email to have them sign off on it. Since it's not a mandated thing, I would hope that we would not have to try to find a.
You can't. If you're going to adopt something on behalf of the committee has to vote to do it.
I agree.
But I mean, it doesn't have to be before next Friday. So I mean, you can do it anytime. If you want to do it in December, you can. It's just a matter of finding a time that's going to be conducive for you.
Can we do it by email?
No.
We must meet.
If you're voting to adopt something, if you're adopting something on behalf of the committee, you have to vote to do it.
Yes, we understand that. The question is, do we have to vote in person to do it?
Yes. 91A.
91A, you are a dear friend. Okay, thank you so much.
All right, Mike.
Okay, everybody get calendars out and let's find a day when we can be here.
What about the 21st?
The 21st has chairs and vice chairs meeting in the morning.
So you already be here, so maybe we could do it after?
Could we?
I have 30 for Thanksgiving, which is very early this week.
All right, everybody.
Can't we do it after?
We can do it
Thanksgiving?
after. Tryptophan will have worn off by Sunday. Okay, can we do it on Tuesday, November 28th at 9:30 a.m.? Tuesday, November 28th at 9:30. Is that doable?
I can't.
I can try to ask if I can switch.
Okay, remember I had asked originally save Tuesdays if possible. Can you do it?
I'm unclear, but I could get, I don't have all my dates on the,
Okay, Representative Gregg? Yes. Long? Give our regards. I heard a learned lecture on leadership traits learned from the musical, and you have to sing it, not speak it. Yes. Okay, bring back a report for us, Representative.
Can't we move into December?
We can move into December. I will be on my
Oh, I have a better idea.
fellowship the first week. What?
Okay, you go
what?
on.
Well, I'm done. Go ahead, what's your
When could you
idea?
do it in?
December 12th. Are you back from Manhattan by then, Representative Long, to run the city of Manchester?
I hope to be.
Okay, can you do it on the 12th? You're what? You're in Manhattan. Do we all get a turn to go to Manhattan? And I never liked gin. I think gin's in Manhattan, isn't it? Manhattan, the drink? I would-
Oh,
I
yeah,
wouldn't
no,
know,
I
yeah.
don't know.
I don't know what's in a Manhattan.
Gin, or is it?
Vermouth or whatever.
I don't know.
Okay.
You know what?
What? No, what's that? 6. And as you know, one does not ever come, but I still need 6.
This is this way. The 16th is a Thursday.
How about Thursday the 16th? You can come. November 16th, you can come, you can come, you can come. What's that? Okay, November 16th
Okay.
at 9:30, special committee. Do not please be dilatory over the weekend writing your reports, however.
That still has to.
So, Mr. Chair,
What? Yes,
thank you.
welcome.
I cannot be here that day.
Okay.
Okay. I've got
Okay. I need a quorum is what I need. And I have one, so
Just
there
wanted
it
to be
is.
clear. Yeah.
Write that down.
Okay.
It's in.
It's in. Thank you for.
Anything else before we adjourn from the committee? Okay, seeing nothing, we're adjourned. Thank you.
Thank you.